Hello and welcome to the Sisters for Fitness Wellness Show. I'm Stephanie Gaines-Bryant. Our guest today is Suren Adams, attorney Suren Adams. She came to visit us a couple of years ago, so I thought it was time to bring her back. We're going to talk today about something that a lot of people don't like to talk about, but it's something we must talk about: estate planning. And she's also author of the book, Leaving a Legacy Instead of a Mess. And I know what you're talking about with leaving a mess.
Mm-hmm. Yeah, that's the thing we want to avoid with estate planning. Hopefully doing it early enough, you can avoid the mess.
And I shared with you that my dad passed away almost a year ago. And we thought that things would be the same as they were when my mom passed away 4 years earlier, but it's a mess.
Yeah.
And I knew I wasn't the only one. So that's why I thought it would be a good idea to have you come and talk about why is it so important to think about estate planning earlier than later.
Yeah, the earlier you can do it, the better. Even with your situation, I think a lot of people fall into that false sense of security when one spouse passes and then the other spouse is remaining. They're like, oh, that wasn't that bad. Probate and estate planning, it's not that big of a deal, it's not needed. But after that second spouse passes away, that's when everything is only held with one person. So that joint tenancy thing is the only thing that's preventing it, and that only prevents it for a while. And then you have the whole probate situation. And so the earlier you can get planning done, the more control you have over what happens when you're no longer here. And you can prevent probate, you can prevent disagreements among family members, all the things that separate families after somebody passes away. They can all be prevented if you plan early enough and take account for all of those things and have it ready if anything happens.
What are some of the things that are included in planning? What should you keep in mind when you're planning?
Yeah, the main documents should be at least a will, but a will does not prevent probate, so you should also have a trust. You should also have a durable power of attorney, and that's for while you're alive, as well as an advanced healthcare directive, which is also for while you're alive. If you have minor children, you should also have some sort of guardianship documents in place, not just with the will, but something that is in addition to that, that names if you're incapacitated, what should happen with my kids.
What's the difference between a trust and a will?
Huge difference. The primary difference is a will goes through probate. There's no way to avoid probate if you just have a will. The way you administer a will is through the probate process, and that is a court process. So you're basically inviting the court system into your family situation. All of the time delays that brings along, the cost that brings along, the administrative burden for your family that brings along. When you have a trust, if it's fully funded, properly prepared, you can avoid the entire probate process. A trust is a private document. It's handled with your family and the person that you name as trustee of your trust. They step into your shoes after you've passed away and manage and administer the trust according to what you have said to do within the privacy of your family. It is not done with a court system. So it is much better in terms of the administration. It can be handled in as little as a day if necessary, or it can be delayed until the family is ready to deal with it, which is not like the probate process, which has its own deadlines and requirements, certain things that have to be filed by certain deadlines. So all of that can be eliminated with a trust. Plus you can be very specific about what you want to accomplish, which is the fun part for attorneys. If you have a specific family situation, like a special needs child or sibling or somebody you want to take care of in that way, you can handle that through the trust and protect whatever benefits they're already receiving. If you have children that are minors and something, God forbid, happens when they're minors, you can set up how they would get distributions, not having things go to them at 18 when they're considered an adult by the law, and then they go and blow it all. You can have a trustee who's managing those assets for them until you decide what age they would receive it. Most people do a distribution at 30, 35, 40, but you can pick whatever ages you want, whatever percentages you want. You can key it to the things that you want to leave as a legacy. So if education is very important, you can say, if you finish undergraduate by a certain date, you can get an early distribution at that date. You can key it to investments, so you can say if you're purchasing a home for either yourself to live in, or if you're purchasing a rental property, you can get a distribution for that. If you're starting a business, you can get a distribution for that. So you can set it up based on what your passions are and what legacy you want to be leaving for your family.
If you have a death in the family, what is the best way to choose the executor?
So the best way is for the person who has passed away to have chosen the executor ahead of time. If the family is deciding who that should be, it really is up to a family decision. Oftentimes it's one person who's just very administratively minded and can handle all of the details of that. But for most families, the time concern for that is just too much, so they hire somebody to help them. So the administrator or executor of the estate or personal representative, there are all these different words for it, that person hopefully is working with an attorney to help them get through that process as quickly as possible. Because it has all sorts of delays built into it, much less the delays that come from not knowing what you're doing. So most families choose to hire someone to help them with it.
What happens when you don't have a will?
When you don't have a, yeah.
When you, because a lot of times things happen unexpectedly.
Right.
And you haven't planned ahead, because especially there are some cultural issues with that as well. Mm-hmm. What happens, and let's scare people, what happens if you don't have a will?
Well, if you don't have a will, the state of Maryland and all states in the U.S. have a will for you. They have a plan already in place for you, and it's usually not what your plan would have been. So things that you're expecting to fully go to your spouse gets split up between your spouse and kids. There are all sorts of things that happen that you are, unless you are familiar with the law, you're unaware of what's going to happen after you pass away. So it's like leaving it into the hands of the legislature and whatever changes they make in the future. So it's a very dangerous plan, and you're guaranteeing that some of what you're trying to leave to your family is going to go elsewhere because there are fees involved. So it's capped in Maryland at 3.6%, but if you look at just a regular estate of $500,000, which in this area is not even regular anymore, that's low, just from the values of homes. So that type of estate can cost up to $20,000 in terms of cost when you're putting it through the probate process. So all of that can be eliminated if you do have something in place ahead of time. Not having anything means you're leaving it to the state to determine what's going to happen, and you're leaving it to your family to kind of fight over who's going to be in charge of that. And then that person who's taken on the burden of doing that, and it is a burden to do that, is then dealing with the family members who are saying, when am I getting this? When is this going to happen? And it's based on the court system. So they don't really have control over all of that either.
Is there a standard way that the state divides things?
Mm-hmm. There is. So for example, if you are married and you have minor children and you pass away, your spouse gets half of the estate and your kids get the other half, which means that it goes into a custodial account till they're 18. Then they get all of that at 18, which is super dangerous.
Yes, it is.
If you're married and you have adult children, it still gets split, but the spouse first gets a spousal allowance of about $100,000, and then the half of the estate, and then the kids get the other half. And that's if the kids are not the kids of the spouse that is surviving. So there are all these rules that are built in, and you have to figure out those rules and get the distribution right. All of those things are in play when you're letting the state decide what's happening.
What is a revocable will?
It's a revocable trust, and the trust is the one where you are deciding ahead of time what to do, and it's kept outside of the court system. So it's the recommended estate plan. A revocable living trust means that you can change it at any time. So for example, you create a trust today. The goal with a trust is that it's properly formatted, set up, it's a legal agreement. So you have to make sure it's done correctly, because after you set it up, you then transfer all of your assets into the name of the trust. Real estate, bank accounts, investment accounts, all of those things. So ideally, nothing is in your individual name. Everything is owned by the trust that you control. And you can be trustee of your own revocable living trust while you're alive and competent to do so, and then you name a backup trustee who steps into your shoes after you pass away. That backup trustee is the person who's administering everything for you after you pass away, or if you're incapacitated. So it can help in terms of adult guardianship. You've already named who you want to take care of things if you're incapacitated. And then you name beneficiaries of the trust, the people who are going to inherit from it after you're gone. You're the beneficiary of it during your life, but you name people who would inherit from it after you've gone, and how they should inherit, which is a key thing about a trust, is you can determine the how.
How often should you review this?
We recommend at least annually. So you want to make sure your estate plan is tracking with your life and any changes in the law, and the law changes all the time in this area of practice. So making sure it's tracking, and that annual update allows for that. If you aren't updating it every year or looking at it every year, at least every 3 years. That's the longest you should go without having looked over your plan to make sure it's still tracking. Are the people that you named to serve in different roles, are they still the people you want to be in that role? Have your kids aged to the point where you said a distribution should happen at this point, and you know that they still would not be able to handle things at this age? Do you want to change those ages so if anything happens, they get a later distribution, not now? So all of those things you want to always be looking at and making sure it's up to date.
We talked some about the probate, but let's get into details. Exactly what is that?
Yeah, I call probate, it's basically like you suing yourself after you've passed away for the benefit of your creditors. So it doesn't make any sense to do it. It's not good. And you can avoid it, so why do it? It basically, when you have, say you have a will, let's do the best version of probate. Say you developed a will and that's all you have in your plan. You may have a power of attorney, advance directive, but those don't matter after you passed away. The will is what's governing it. And this is not the intestacy probate where you don't have anything. This is where you've decided who you want to inherit. So you pass away, the person you've named in your will would then have to go and take that will to the probate court and say, this person has passed away, they told me to distribute these things according to what numbers are in here. And the court has to then say, yes, this person has passed away, yes, you're the person who they've named, and here's your authority to go and distribute these assets. That authority is called a letter of administration. And that's why a will has to go through probate, because otherwise anyone could take your will anywhere and just say, they said I could have this car, give me this car. You need a formal process to say, now is the time you can go and distribute that car. So with that whole process, there are certain deadlines, certain documents, certain formatting that things have to be in order to be accepted by the court, and it has to be open. In Maryland, it's a minimum of 6 months that the estate needs to be open for creditors to be able to file a claim against your estate. So that's an invitation to creditors to file a claim against your estate. And also, if you say you have in your will somebody in your family that has already benefited during life and you don't want them to inherit out of your will, they still get notice in the probate process of you passing and that the estate is open, here are the assets of the estate. So it also invites conflict among family members in that way. Anyone who would have inherited if you didn't have a will gets notice of the estate, even if they're not in your will.
What if you do a will at one point and then do a later will? Which one?
The later one, if the language is written properly. The later one is the one that should govern. So if you did a will, the later will, every will should say, this is going to revoke any prior will that I did. But we find all the time where people have tried to do this on their own and things are not done properly.
Please, let that be my next question.
Yes.
Is it smart to do this on your own?
100 times no.
I see the commercials on
all
TV
the time.
all the time.
Yeah.
Here, it's easy. All you have to do is...
No, you can think that you have crossed every T, dotted every I, and done it perfectly, but you don't know what you don't know. So something you have said or done or in that document could be creating the mess after you're gone, and that's usually the time that families find out that it was done incorrectly, is after it's too late. So now you're cleaning up the mess and mourning somebody and dealing with the probate process. So highly recommend you have professional help when doing any kind of estate planning, because that, number one, is where you get introduced to the better method of doing it. and the better way of doing the plan that you're trying to accomplish, and making sure that it's done in a legally binding way so that it actually is going to work. You don't want to create something trying to save money on the front end and then creating a bigger mess and costing more money on the back end. A good estate plan is 4 times less than probate. So there's no point in trying to do that because you're not saving the money at the end of the day.
Now, when you do workshops, because your office does workshops on this particular subject, what should you have with you? What should the people have to come prepared for what you're about to discuss with them?
For the workshop, absolutely nothing. You just come with a listening ear to be able to absorb the information. We have things for you to take notes even in there. You don't even need to bring a pen. Just come with the listening ear. I find that what we have encountered is a lot of times people will go to either workshops on estate planning or they'll read up on estate planning, but they have preconceived notions about estate planning. And still after hearing the better method, they're like, no, I just want to do this. I just want to do a will. When they've got real estate, they've got minor kids, they've got all these situations that if you do a will, you're creating a problem. So the listening ear, but also the openness to learn a better method of doing things, even if it's unfamiliar. And that's where, to me, the trust comes in. You definitely have to trust the person who's preparing your plan. If you don't, if you have some feeling underneath, like, I don't know if this person knows what they're doing, back out of that because you want to have the faith in that.
This is one of the biggest things in life
Yes.
you're going to be confronted with.
Yes.
So you really, really need to trust
Yes. You
who
really
you're
do.
working with.
You really do. To me, the biggest compliment is when I send an estate plan out, and I have a team now, so I've trained them all exactly how I did this for many years. But when sending out an estate plan and somebody reviews it super fast, so you know that they have skimmed. I mean, I ask them to review. We send a plan ahead of time, which is another thing you should be looking for, so that you can read it and know what's in your plan before you're at the table signing off on it. So when I send it to somebody and they respond very quickly, it looks good. That trust is what you need to feel, that you've spoken enough with the person that they know what your goals are, what you're wanting to accomplish, and they have the skill level to be able to put that on paper to make it happen. That's one of the biggest things.
What if you have an elderly person you've been taking care of and you want to make sure that their affairs are handled beforehand? How do you do that?
That one is a tough one because I have elderly people in my life as well. They generally do not like when somebody younger tells them what to do. So sensitivity to the fact that they are making their own decisions about their own affairs. So introducing them to something like a workshop, I find, is the easiest method to do this, rather than saying you need to go and get a trust. Is saying you need to go and listen to this information and let them decide that they need to get a trust. When they hear the information, that will be their determination too, but they do not like to be told what to do. It needs to be that person's decision. If they're competent to make their own decisions, they make their own estate plan. Even if you have input about what you would want in there, you can give that input. But it is, at the end of the day, their assets that they worked long and hard to get, and their decisions about how it's going to get distributed and who should be in charge of that.
If you have someone, let's just say, who's under guardianship, can you have a family member help create a trust?
Then it's too late. If the documents were not in place ahead of time for them to say, for example, if somebody has a power of attorney, you can have your power of attorney say, this person has power to create an estate plan for me. But if they pass the stage of doing that and now they have a guardian over them to manage their affairs because they didn't have a power of attorney or didn't have any kind of estate plan, then it's too late. That's why I always say the earlier the better.
In your 20s, 30s, 40s, what's considered early to you?
Everyone is shocked when I say this, but as soon as you turn 18, you should start getting an estate plan in place. And I'm not saying you have a will and a trust at 18, because you still have no stuff at 18. You've got your bed, which is really not even yours.
No.
I know, right? They think they have stuff, but that stuff is our stuff. But at 18, you should have a power of attorney. You should have an advance directive, because if you go off to school and something happens, your parents no longer have any legal authority to go into your bank account if you have your own bank account, to handle your financial affairs if you have a vehicle in your name, to get medical information, which is the scariest part.
Yes.
If something happens. So you want to have those documents in place saying, here's who I'm naming to handle my affairs if something happens to me. And then as soon as you start gaining assets, so a house in your name, bank accounts of any substantial value, meaning you're not putting in a paycheck and everything is coming out 2 days later. That's not really an asset yet. But vehicles in your name, bank accounts of substantial amounts, when you start getting life insurance, and that starts happening usually as soon as you have your first decent job.
Yes.
You have some form of life insurance at that point through your employer, and any kind of retirement accounts, because you need to be designating who should get things if something happens.
In estate planning, there are certain terms that we should become familiar with, like guardianship, like advance directives. How important is it to have an advance directive?
Very important. We learned the importance of that in spades during the pandemic, because without that kind of document, what was happening is people were admitted to the hospital with COVID. They were then intubated, so they couldn't communicate. They couldn't speak. And then no one was allowed into the hospital with them, so you couldn't see what was going on. So unless you had some legal documentation to say, you can talk to me about what is happening with this family member, this loved one, families were completely in the dark. It was very scary. So having a document in place like that ahead of time is super important, so your family can know what's going on and help make any kind of medical decisions if you are unconscious. And it also allows or prevents the end stage situation where at end of life, doctors can basically solicit from any interested persons what to do in terms of life support. So if you have one family member, one friend who's involved at the hospital and they're like, no, they wouldn't have want that to happen, don't do this, it can throw a monkey wrench into what should be a time where family is supporting each other and taking care of each other, one person making that decision. You should have it in place ahead of time saying what you would want to have happen in that situation, whether you want all available artificial medical treatment indefinitely for as long as possible or you don't, and say that. And so your family then just has the honor of carrying out your wishes. And one person is designated to do that. And then everyone can just support that they did what was requested.
And it's so important. My dad, as a matter of fact, he decided he didn't want any other kind of treatment. He just wanted to be able to pass at home, spend his last couple of days and hours at home. He didn't want any resuscitation and things like that.
Right.
But then there are other people who may want to do everything you could possibly do.
Right.
And it's just sad that we went through this during COVID, and a lot of people didn't get what they wanted.
Unexpected.
Yes.
That was such a rough time in so many ways that all of us handled it in different ways and had different things going on. But for families who lost someone, it was horrible because it was unexpected. It wasn't like somebody had been, sick and you were expecting this to come. But it just felt completely out of control of people who were left behind. So you didn't know if you made the right decisions. You didn't know if care was done for, everything was just out of everyone's control. So I'm a little bit of a control freak, and for me, estate planning can be that. You have control from the moment you put your plan in place beyond after you've left. So it was a very rough time.
And everybody knows somebody who passed of COVID, whether it's a cousin, whether it's a coworker, everybody knows somebody. So it was just an incredible time that we don't want to see repeated. That's why I think this show is so important. Make your plans early.
Yes. Nothing is guaranteed to any of us. And if anything, the pandemic taught everyone that one lesson. Nothing is guaranteed. And I mean, you could be perfectly healthy and not of an age where you should be passing away. And anything can happen, but to have the ability to do that well and to have part of your legacy be that I thought this through and made this as easy as possible, a very difficult thing, as easy as possible as it could be for my loved ones. and set things up ahead of time. That is such a gift, because we have seen those cases where somebody has contacted us on some minor thing that was not handled, but they said, I'm so grateful they did this ahead of time because it was so much easier. And I just have this one thing, this one bank account did blah, blah, blah. And we're dealing with one minor matter, instead of everything is a ginormous mess, and we're cleaning up all over the place, and the family's trying to mourn at the same time. So, yeah.
What other, as we wrap up the program, what are some of the other types of issues that you handle at your firm?
We do everything kind of related to estate planning. It really is our passion area. So estate planning, of course, and then probate, because we have clients who have come after this process where they haven't put things in place, and the family members are now dealing with it. So we help with that. Guardianship is the other area, because—
And you explained to me that guardianship isn't just for kids.
Right.
It's for adults as well.
Exactly. So adult guardianship is when you are incapacitated beyond where you can be making your own decisions, and you don't have any documents in place to say who should be handling things for you. So then your family has to go to court to get the court to decide who is in charge. And then you have yearly responsibilities in terms of filing and so forth. So it is not ideal. Ideally, you've decided when you're competent and said who should be in charge, and they just carry out your wishes. But we help families with that as well.
And so, you do monthly workshops on probate?
On estate planning.
Estate planning, I'm sorry.
So yeah, probate and guardianship are kind of the areas we feel obligated to help with, but we don't enjoy. Estate planning is our passion area, because it's creative, you can help leave a legacy for families for generations to come.
And it can be the way you want it.
Exactly. You decide how and when and all of it. So it's an honor when we help families do that, and it's also very fun for us to do that. That's what we enjoy. That's our passion area. So the workshops are on that. Let's clean things up now so that later it's not a problem.
And we will give your information, because you have two locations. You have one location in Bowie and a satellite office in the Washington, D.C. area. So at the end of the program, we'll give all of your information and how people can contact you and how you can attend this workshop. You can't go wrong. You can't go wrong with planning ahead.
And getting information. That to me.
Information is power.
Yes. Exactly. Knowing what you don't know and getting some way of fixing things ahead of time.
And the name of your book, one more time.
Leaving a Legacy Instead of a Mess.
Don't leave a mess.
Exactly.
We've been talking to attorney Suren Adams, who has an office right here in the Bowie area. And as I said, we will give your contact information. It is such a pleasure. Don't make it another 10 years before I see you again.
Yes, please.
You've been watching the Sisters for Fitness Wellness Show. I'm Stephanie Gaines-Bryant. Enjoy the rest of your day.